Good afternoon all, and welcome to another webinar where we get up close and personal with Sabrina Allen, also known as the Godmother of Notes. I'm Joe King, your host, and before we begin, we want to thank our sponsors for making this possible. Up on your screen right now are some of those sponsors: Revival Brothers, LOI Events, which you can find on loievents.com, The Ideal Property Analyzer, and The Art of Notes. If you guys get a chance, please check out their websites. Please check out what they have to offer, because I think that the resources that you find with these companies will definitely help you become a better investor. So with that, today's topic is understanding bankruptcies as they relate to investing in notes. I want to introduce to you right now Sabrina Allen, who's president of Main Street. She's an experienced note investor, and also has been in the servicing industry for how many years now, Sabrina?
5.
5 years. So has seen just about everything related to notes inside and out. And with that, I'm going to turn it over to you, Sabrina. So go for it.
Good afternoon, you guys. Thanks for joining us on this webinar. And one of the reasons why I wanted to go over bankruptcy is because a lot of note investors seem to be pretty fearful of loans that they see on a data tape in bankruptcy. Just want to point out a couple of things, and I'll maybe go a little bit more in depth if we have time after I just kind of explain what a Chapter 7 is, what a Chapter 13 is. I'm not really going to talk about Chapter 11 because I'm not well versed in Chapter 11. Right now we have a case that's a Chapter 11 and the borrower is representing himself, and it's a nightmare. So I'm not going to really talk about 11, but it's a bigger challenge, it's a bigger beast. And in our world, all the years I've been doing this, this is the first Chapter 11 that I've ever experienced. When you see a data tape that has a Chapter 13 on it, just make sure that you actually go to the docket in Pacer to make sure that there's not a lien strip in place. And then if it's a Chapter 7, Chapter 13 on a first lien, you just know that you probably are going to hold on to that loan a little bit longer than you possibly anticipated. So with that being said, we're just going to kind of get started. This is going to be just, I say, a crash course in bankruptcy through lunch. And if you guys have questions during my presentation or at the end, I am willing to answer any questions that you may have.
Just so everyone knows, there's a Q&A at the bottom of the webinar. So if you click that button, you can ask a question, and it'll pop up on my screen, and I'll go ahead and ask Sabrina. Go ahead. Didn't mean to interrupt.
Oh, that's okay. You can go ahead and move to the first slide, Jeff, please.
Okay.
So you guys, just so you know that I'm not giving you any legal advice. I just need you to understand that this presentation is for information only. And if you need to seek legal counsel, do so. This is just basically per my experience, and I just need to say that. I don't want to end up with, Sabrina gave me legal advice during her presentation. Confirm but deny, confirm but verify.
Right.
Go ahead, next slide, Joe.
Okay.
So Chapter 7 is really basically the most common bankruptcy that's filed in the U.S. Some things have changed in some recent years, where now the borrowers have to take a means test. So basically, they have to actually meet some requirements in order to be able to file bankruptcy. And the reason that was put in place because you just have people who abuse the system. Every 7 years that they could file, they would file. And it relieves the borrower of paying most debts. And I say most debts. It does not take away IRS tax liens, property taxes, and student loans. You cannot bankrupt student loans. Most of the time, they are also, it's filed to stop a foreclosure. So a lot of times in our space, when we actually see someone filing a Chapter 7 or filing a Chapter 13, it's because it's a day of or the day before foreclosure sale. and they are protected under the bankruptcy stay, and it protects their assets while they're in bankruptcy. Sometimes when people file a bankruptcy, that does not mean that they're willing to walk away and they're surrendering the property. Normally it means I want to stay, but you wouldn't work with me as the lender. So when you're negotiating with a borrower that's really tight on money, and you have a foreclosure sale coming up, always in the back of your mind think that there's a possibility that the borrower could file bankruptcy. And sometimes we think, they say they don't have $2,500 to put down to start a payment plan or a modification or forbearance agreement, but they'll go take that money to an attorney to protect them from foreclosure. So again, always keep that in mind when you're playing hardball with a borrower who's backed up against the wall, who really has emotional equity tied up in their house, whether it's a first or a second mortgage. Go ahead to the next slide, please. Chapter 13 is a little bit different. Chapter 13 really allows the borrower to keep the property as long as the plan that they submit to the trustee is accepted. Normally plans are about 60 months. The borrower must prove the ability to repay. So they actually have to submit their income and all of their assets into the Chapter 13. And the plan has to be approved. And when I say the plan has to be approved, it means that they actually have to have a schedule of either their secured creditors or their unsecured creditors, and also have the ability to pay back. And the other thing is, and I'm not sure because I did these slides a while ago, if we talk about a proof of claim and a transfer claim. If I don't address those on the slide, we will talk about those. When you're filing a Chapter 13, your debts can't exceed $1.1 million, and your unsecured debt can't exceed $384,000. And if they do, that transitions you into a Chapter 11. And as I stated, I'm not well versed in Chapter 11, so we're not going to talk about it today. Next slide, please. Go ahead and go back to the next slide, because I do want to talk about a proof of claim and transfer of claim. So when you get notice that a borrower has filed a Chapter 13, you need to file a proof of claim. Generally, that is done by an attorney. The proof of claims have kind of become a little bit labor intensive, and you have to have a lot of information when you file a proof of claim in a Chapter 13. If you buy a loan that's already in an active 13, you need to be able to file a transfer of claim. It is very important that you're not buying from somebody that is going to take you 6 months to get your collateral, because normally you do not have any rights to collect any payments in the 13 until you have provided that transfer of claim, and hoping that the previous owner of the note did file a proof of claim, because if they didn't file a proof of claim, you can't file a transfer of claim, and you may be, even as a secured creditor, be treated as an unsecured creditor in the Chapter 13. That doesn't eliminate the lien on the property, but it does make some challenges for you to be able to collect while they're protected under the Chapter 13 bankruptcy. If you don't understand, if you don't know, reach out to someone that can help you. I will not tell you that all servicers are friendly about answering questions for you for your bankruptcy. They will basically tell you that you need to reach out to a local attorney that's going to represent you, and they will provide documentation to the attorney to be able to prepare the proof of claim or the transfer of claim.
Now this proof of claim and transfer of claim, is this only related to Chapter 13?
That is correct.
Okay.
And also, kind of want to talk about it a little bit about if you have a second mortgage in a Chapter 13. If you have a second mortgage in a Chapter 13, and we're going to just use round numbers, the property's worth $200,000 and the first is owed $231,000. You heard me say if the value is $200,000, but the property but the borrower owes $231,000 on their first. So that means that property is underwater. If you have a second for $10,000, if you have a second for $30,000, there's a possibility that the borrower can petition the court for a lien strip and treat you as an unsecured creditor in the 13. So I don't know if I have more first people or more seconds people on the phone, but you do have to know that when you're doing your due diligence, when you're pricing your loans, if you're pricing a loan that's underwater and doesn't have equity, you need to price it accordingly. I don't care how much emotional equity is there. If you're planning on pushing forward on foreclosure or trying to get that borrower to pay, make sure that that property is not so far underwater that they're going to file a 13 and lien strip you. Joe, do we have any questions?
The only question we had was, will this video be posted later? And the answer was yes. I believe I answered that in the chat window. But if anyone has any questions related to Chapter 7 or Chapter 13, please ask it now. We have a little bit of time left over, so we're hoping that we can get some good questions and be able to answer them for you. So go ahead and fire them off.
So also I want to talk about, what if a borrower is representing themselves in a bankruptcy? That is very challenging. You cannot reach out to the borrower, and if you don't know what you're doing or you don't know how to address the borrower and they're representing themselves in a bankruptcy, I would just recommend that you just don't reach out to the borrower if you're trying to get any information on what's going on with their file. It's different if they're represented by counsel, because you can always reach out to counsel and they'll answer. Counsel will generally answer questions for you on what their client's intent is, but not reaching out directly to the borrower. Joe, I saw a question pop up. But
yes, I own a loan in Chapter 13, but don't know when the BK is scheduled to end. Where do I find out?
You can actually go to Pacer and you can look at the docket, and it'll tell you when the case was open, and it will tell you when the plan was approved and for how many months. And then you're just going to have to count backwards from there.
Mm-hmm.
And also, when you go into Pacer, Pacer is where you actually can go in and you can check manually when you're doing your due diligence to see if a borrower is in an active bankruptcy, a closed bankruptcy, or a discharge bankruptcy. As long as you have their social security number and their name, generally you can find that information. Any pages that you download on Pacer is about 10 cents a page. And generally you have to open an account and secure that account with a credit card, and they just kind of bill you. I don't know, I don't really look at my bill. I don't download too much. I just basically view the documents. But you could rack up maybe $5, $10 a case by just kind of clicking on the links to familiarize yourself with the documents that you can see in Pacer.
And I believe that's Pacer.com, isn't it?
I have so many things on default. I can't answer that question for you, Joe.
Let me just look real quick.
Okay. I think it's Pacer.gov.
Yeah, I think so too. Let me just verify. Yes, it is. It's Pacer.gov. So for those interested in checking that out, go to Pacer.gov.
And so I'll do another training with just basically walking through the proof of claim, what that looks like, walking through the schedules. But it's just too much in 30 minutes. So I figured I would just do a quick, brief overview of Chapter 7, Chapter 13. Don't be afraid, just some kind of nuggets to basically look for when you're doing your due diligence on a data tape, looking on buying a loan, and actually planning on some extra holding time when you actually buy a loan that's in bankruptcy. So the other thing that I want to talk about, you guys, is that when a loan is in a Chapter 13, the borrower has the option to pay their arrearages inside or outside the plan. Inside the plan means that they will send a check to the trustee every single month, and the trustee will release a payment to you. it seems like they release a check maybe every 60 days when the borrower is paying on a consistent basis. Or they can make the option of paying their current payment outside the plan and also their arrearages outside the plan. And most of the time when you go into an active Chapter 13, whether it's a first mortgage or a second mortgage, those arrearages are locked in at a 0% interest rate. So once they cure them over the 60 months, they also have to continue to make their current monthly payment. If not, you can actually file a motion in court for the trustee to dismiss the case.
When it's dismissed, does that mean it goes into foreclosure, or how does that work?
So before you can move forward with foreclosure, you have to get relief of stay, whether in a 7 or a 13. And sometimes you can get a relief from stay while an active 13 is going on. But it just seems like the 13, Chapter 13, and the trustees in the 13s are just, I don't know, they're like Mother Teresa. I mean, like, even when they go delinquent, when you motion for the case to be dismissed, you will normally find that the first time you request for the case to be dismissed, they won't. The borrower kind of will get a smack on the wrist on basically them inquiring on what went wrong. Can they cure it? Normally, if they can, the 13 is not dismissed.
Okay. So we have a few questions here.
Okay.
How can we factor in a Chapter 7 and 13 into note pricing, into the offer price? So I think the question is, if they're going to make an offer, how can they factor in that BK into that offer price?
So if it's not in bankruptcy, it's really not. It's never been part of my formula to factor it in. That's number one. But so let's say if a borrower is in an active 13. Sometimes the seller may be treating that as a performing loan and you're going to pay more money for it. But also, if you buy that as a performer, make sure you know that there's going to be a lag in time before you actually are going to get payments, because you have to file that transfer of claim. And you also have to make sure that the day you fund or the day you purchase, your seller is actually going to forward you those payments. Generally, they do. But sometimes, I'll get a phone call from somebody saying, hey, I sold this loan, but it was in a 13 and the buyer haven't filed their transfer of claim. Can I keep the payment? No, you can't. To me, that's unethical, especially when you know you sold the loan. But I get those foolish questions sometimes. And then in a 7, the only thing that you really have to factor in is time. If it's in an active Chapter 7, you have to know that you can't move forward with any type of legal action until the bankruptcy, the Chapter 7 bankruptcy, has been closed or dismissed.
So we have another. Go ahead.
And so normally what I would do is I actually will offer maybe anywhere from 15 to 20% lower on what I would normally offer, because I know that there's going to be some holding time that I'm going to just have to sit on that loan if it's in an active 7. If it's in a closed or dismissed status, you can move forward with foreclosure as soon as you buy it.
Okay. So we have another question.
Okay.
In Chapter 13 bankruptcy, if there's a first and second on the property and the property is underwater, if I have a second on the property and the judge orders it lien strip during the payment plan, will I always get unsecured payments? And if so, will I take priority of all the other unsecured creditors?
So it depends on the trustee. If there's money left over, sometimes unsecured mortgage does get priority, but I don't really know how that's ruled or how the trustee makes that decision. And what's the other part of the question, Joe?
And if so, will I take priority over all the other unsecured creditors?
I don't know if it's law or discretion, but what I do see a lot of times on our stuff that we're an unsecured second, we see that we're priority. So the other thing that I want to tell you all, that in a Chapter 13, if the borrower does not complete their plan and the case gets dismissed, your lien is still a valid lien. So, watch it over the 60 months and maybe check it. We check it every quarter. We check them quarterly to see if they've been dismissed. And if they've been dismissed, you have a right to reinforce your lien, even though a lien strip was granted. But if they don't complete their plan, that is null and void.
Okay. We have another question from Don. After plan submission, how long does it usually take for the trustee to approve or reject?
It really depends on their caseload and what district they're in. Sometimes it happens really, really fast, and sometimes it doesn't. Is that Don Rickenbaugh?
Yes, it is.
Okay. Hi, Don. The other thing is that sometimes there's a lag because the borrower who has filed a Chapter 13 has not submitted all the required documents to the trustee or to the court. And if they haven't completed their testing as well, or their counseling, it's not testing, but if they haven't completed their consumer credit counseling course, that could also be a delay. So they're given I don't know how many weeks they're given to complete that consumer credit counseling course as well. So it's a lot of things that could take place before you see if the trustee is going to approve or reject the plan. But if income does not support what needs to be taken care of, generally the trustee will reject the plan.
And then Don also has a question. In a 13, at what point do you usually hire an attorney?
Good question. It depends on how comfortable you are in interacting with the trustee. A lot of things that, but we have 2 attorneys on staff as well, but we've been doing this for so long in-house that we generally don't hire counsel unless they're in the process of trying to do some form of a lien strip or do a cram down. Lien strip is basically trying to eliminate our lien, and we know there's equity, or if they're trying to do a cram down and we feel like the value is greater than what they're stating in the Chapter 13, that's when we normally will hire counsel. Other than that, we handle it ourselves internally. But if this is out of the scope of something that you feel comfortable doing, once you filed your proof of claim, I would maybe retain counsel just to maybe show up at the first creditor's hearing to maybe see what's going on. But if the first creditor's hearing has already taken place, I would just wait to see what the trustee's going to do.
Okay. We have another question from Marco. He has a loan where the borrower filed a Chapter 7, but it was dismissed. I'm seeing evidence that she may be looking to file again. Is there a proactive strategy to handle that?
Is this a first or a second?
Don't know.
Okay, so
it's a first. It's a
first.
Yeah.
So what I would do is I would look to see if they were represented by counsel in that first Chapter 7 that was dismissed, and call the attorney and tell the attorney that you're willing to work with the borrower if that's something you're willing to do. Basically, that way you could actually get them to maybe do a forbearance or a mod. And if they're only filing because they think that you're going to foreclose, maybe, take that non-performing loan, get them paying for 6 months to a year, and then sell it off, and you still get your chunk of change.
Okay. Let's see if there's, I think that's all the questions. Does anybody have any additional questions related to bankruptcy Chapter 7 or 13? So maybe it would be beneficial to maybe walk through the process of mediation in the judicial system, Sabrina, if you would. Because I know a lot of people have asked me that question in the past, and not having gone through too many bankruptcies, I typically don't know what the answer is related to how the actual bankruptcies are resolved through the mediation. Could you get into that a little bit?
Really, really there's not a mediation hearing. There's basically a meeting of the creditors. So
Mhm.
mediation is really different, and that's more on the foreclosure process. For mediation, basically, a bankruptcy is they file, they're protected under the stay, and you're in front of a trustee, which is an attorney that's appointed by the court.
Mhm.
If it's a 7, basically they go into court, they make a statement that they don't have the ability to pay their bills. If there's anything that they're willing to reaffirm, sometimes you will get a borrower to reaffirm their car and their house, but based off of a lot of attorneys nowadays, they just tell them to keep paying or don't pay until somebody shows up.
I see.
And then a 13, it's still the same thing. When you have the first meeting of the creditor, that's questionable if an attorney needs to be there or not. Just depends. As long as you filed your proof of claim, you're protecting your asset in the bankruptcy. So you don't really, as a creditor, unless there's something really, really going on that seems to be almost criminal, you don't really get a lot of say when a borrower is filing a 13 or a 7. But maybe we need to maybe we'll do a call or a webinar on judicial versus non-judicial and mediation hearings and what those look like in a foreclosure. I think that would be what we could do next.
Yeah, that sounds actually really good. We do have one other question here. If the borrower has a bankruptcy on record, can they file again?
Yes, they can. So something else that can happen is if a borrower has been discharged from a Chapter 7, and after they've been discharged and you start foreclosure, they can transition into a 13 to protect them, and they don't have to wait 7 years. Same thing is if a borrower if they've completed their 60-month plan and from a 13, and they can't work something out and they fall behind again on their payments with you, sometimes we see them automatically go into a 7. So those are things that you need to know that a borrower can do when you're pushing them up against the wall to get more money, feel like they have more money. You have to use some type of judgment, and you have to enter with caution. But I think that all people who file bankruptcy are not bad. Things just happen. Life has happened, and you have to remember that. It can happen to any one of us, no matter how much money we have sitting in the bank. One bad illness, one tragic accident in your family, it can throw you completely off course. Even though these people have been paid sometimes on the stuff we see for 8, 9, 10 years. It's still good people out there.
Yes, there are. I think we have time for a couple more questions. If anybody has a question, we do have one here. What's the first step for an investor once they've been notified of bankruptcy or once they've found out about bankruptcy? And I think that comes back to what you were saying before, your proof of claims and transfer of claims, right?
Right. So, so if you have loans and you're self-managing and you don't have a servicer doing it, most of us across the board, we have an automated system that we actually load up and we check bankruptcies every single month. If we get a hit internally, we let the investor know that the borrower filed a 7, the borrower filed a 13. So we don't really go past 30 days without knowing that a borrower has filed a 7 or a 13. If you're managing your loans on your own, you need to manually make sure that you're checking your loans once a month or every quarter. And once you find out that somebody has actually filed, then you complete your proof of claim. And so some of the documents you need in a proof of claim. So I stated when I started talking that, you can't buy from somebody who sometimes it takes you 6 months to get your collateral, because that's very important. You can't file a proof of claim or a transfer of claim without a note, a mortgage, a deed of trust, all the assignments, a complete assignment chain, and all the allonges. If you don't have those documents, you guys, you cannot file a proof of claim or a transfer of claim. We have one right now. I've been trying to get assignments and allonges for 6 months. The deadline to file the proof of claim is, I think, Tuesday or Wednesday. And now it's my fault. but I have several emails stating I needed these documents in order to be able to file, and I didn't even sell the individual the loan.
Interesting.
I see you have another question, Joe.
Yes, we do have another question here. How do you handle, think about, or adjust for the statute of limitations? If they haven't paid for 8 or 9 years, isn't there a high chance that you've passed the statute of limitations in most states?
So, and that's why there's two instruments when you do a loan: a note and a mortgage. And sometimes you can exercise the right to enforce the note, or leave the mortgage there. I will still buy loans that old and that are delinquent, but I don't pay market price for those loans. So unless the foreclosure is challenged, a lot of times you don't get pushback from the court about statute of limitations. You know, a lot of people get caught up all into the statute of limitations things. And to date, I have not been challenged in court on statute of limitations, but I've been challenged on payment, you know, when the last time they made a payment, if they made a payment, when they made that payment, how they made that payment. They may challenge the delinquency. And so what we do sometimes, I'm not going to say online, I'm going to scratch that because I've just been quoted in too many discovery cases of what I said we do. So I'm not going to do that, but there are ways around that. We can talk offline if you guys want to call me one-on-one.
Okay, fair enough. I think we're getting down to the wire here. We may have time for one more question. And the question looks like, what's the main difference between Chapter 7 and 13?
7 basically wipes all of your debt. You know, it just wipes everything. And if they file a 7 and they have a mortgage, you can enforce the mortgage. You just can't pursue the person individually. So again, you also have to make sure you know how to talk to someone who's still remaining in their home after they've been discharged from a Chapter 7. A Chapter 13 is reorganization of debt. That's all the 13 is. It's restructuring the payment history or the ability to pay because they got so far behind.
And I think there's actually people out there that are looking for deals that are in bankruptcy because they found ways that they can profit off of that. Is that correct?
That is correct. Again, a lot of times if it's in a 13 and they're already paying, a lot of times now people are selling those as reperformers. So probably about 7 or 8 years ago, whether the borrower was making a payment or not making a payment, 13s was just stuff people wanted to stay away from until people actually got wise in our arena, in our circle, that a 13 wasn't bad if the borrower was actually paying. It's instant money. You just, you know, file your transfer claim and here comes the money.
Yeah. Okay, well, I think that is all the time we have today. If you have any further questions, please feel free to email us in the email addresses that we've sent out for these webinars. Oh, it looks like we have one more last question. Do we have time for one more question, Sabrina?
Absolutely, Joe. Anything for you.
Okay. As a note investor, how can we navigate through note Chapter 7s and 13s, not just being patient till it closes or is dismissed?
One more time with that question.
As a note investor, how can we navigate through a Chapter 7 or 13 and not just be patient until it's closed or dismissed?
Don't buy it. Don't buy it. Sell it. You know, there's no way to navigate, because if you contact the borrower when they're protected under 13, you're violating law. That is why they're protected. So you're violating FDCPA. You're violating the protection of the court. So when you do that, you know, if a borrower challenges you, you're going to be in court for a different reason.
Okay. Well, I think that that just about wraps it up. And I think before we leave, I wanted to mention something related to our sponsors. in March, Sabrina's putting on a mastermind, and it's in Reno.
It's not March, it's April.
I'm sorry, April, my bad. And if you're interested in it, go to shop.noteinc.com/Reno-mastermind, and you can learn all about it and actually sign up through here if you want as well. Or you can go to loievents.com and you can click on more information, and it'll take you right to everything related to the event. So did you want to add anything to that, Sabrina?
So anyone listening to the webinar today, we are going to give a $500 discount until Sunday on the mastermind, and your code would be IPA. So we're willing to do that until Sunday. That'll kind of pretty much cover your, depending on where you're coming from, at least your flight or a night of your room. And then also, Belinda Savage will be present at this mastermind, and so also Sherry Hill. Belinda Savage is with M2 Trust now, correct?
Yes, she is.
And Sherry Hill is really a dynamic person to connect with, who will help you set up serious LLCs. She does asset protection. She is a wealth of knowledge. And those two individuals will be our special guests at the mastermind in April.
Okay. And also I wanted to point something else out. How many people can I get a show of hands out there? How many people are going to PaperSource that are on this webinar? There should be like a little hand thing at the bottom of your thing. Oh, I got quite a few hands going up. So at PaperSource this year, we're going to do an after-hours get-together, and it's going to be Sabrina, it's going to be Zarina, and I think who else is going to be in there, Sabrina? Do you know?
Is Belinda going to be present this year?
I'm not sure. I'll have to ask her, but I think it's going to be Belinda as well. So we will all be there, and we'll have kind of like a little panelist thing going where you can do questions and answers. It's more of a get-together and a networking event than anything. We're going to have some free drink tickets that we're going to be giving out for that. There's going to be some snacks as well, and it'll be at the top of the Palladium Hotel right next to where we're going to be. So it should be a fun event, and I'll be sending some marketing out on that in the upcoming week or so. So be on the lookout for it, sign up for it. It's all free, and it should be a fun event. With that, did you want to add anything else, Sabrina?
Last but not least, I will also be co-hosting an event in LA on, I think, June 18th. It's summer school hosted by Terrence Evans, and I will be co-hosting that event. And you'll have it, I think there's information on the LOI events website or page in reference to summer school with Terrence Evans in the LA area.
And if not, just email us and we can point you in the right direction. I think that's it, just about it. So I just want to thank everybody for coming today. And again, if you have any questions, fire them off to us and we're happy to help. Next week, it looks like we might be talking about, let's see, what did we talk about today? We're going to get into mediation and the judicial versus non-judicial system. Is that what we're going to focus on next week?
We'll discuss judicial foreclosures versus non-judicial foreclosures, and also the cost you could look at. You can run up in mediation in some of those states.
Perfect.
Okay.
Well, with that, everybody have a good day and enjoy the rest of your lunch, and we will see you next week. Take care.
Thank you guys. Have a great day.